It's been a pleasure, sir, to have you on board with us at the Bar and Benches exclusive interview series.
I am also very much delighted and excited.
Sir, it's been, I think, 18 years since the last time you were discharging your roles and responsibilities as a judge. Um, do you miss being on the bench?
I really very much miss that period, and I wish I should have some more period on the bench, because I could not do what I wish to do as a sitting judge. My personal opinion is that once a person goes to Supreme Court, he must have a fairly long period, minimum 5 years, so that he can perform and give something, contribute something to toward the growth of law, and do something for the society. Because I was there only for little more than 3 years. That is too short a period. And initially I did not occupy the constitution bench. Only in the last phase I could occupy, and even I could head the bench only for 2 years, 1.5 years, something like that, as a presiding judge. So what I think is that if the judges in the foreign countries have lifetime appointment, at least we can have an appointment till a person is fit, like you can say 70 years, 75 years. I mean, you are at the zenith of your career, and at the time you are asked to go away.
I was just saying that you are absolutely fit now as well. You still held the
Yes, yes, and
position even now.
as a matter of fact, all our judges, including me, after retirement, did so much of work. As for 5 years in on Human Rights Commission, I had been touring, going to the places, meeting people, working just like a political leader, lecturing, writing. If for 5 years, and after 5 years, I am till now, till up to this commercial litigation of a very complicated nature I am handling. So if I can do arbitration, why can't I decide cases?
Sir, do you think the relationship between the bar and the bench has become more fluid now, in the sense it has become more accessible and open to the public eye now compared to when you were holding office?
This is the effect of IT technology, nothing more than that. Previously, everything that is happening in the court was not coming out in the public.
Right.
But today that situation, and that should remain. I think that this is a good development. Everything that happens inside the court, outside court, must be in the public domain. As a matter of fact, you will find in my book, which I have written, Restructuring Indian Judiciary, I said the entire court proceedings should be seen online, and there should be a camera outside in the on the lawns of the court, so that anybody from the public can watch.
Right.
That is the concept of open court. Courtrooms are have a very limited accommodation, and particularly old Supreme Court, even lawyers don't have fine place. They have to jostle with each other in the corridors. So better it is on the lawns you put a big screen, so that
Okay.
public can come and watch the proceeding.
So in a way, you are asking for a live telecast.
Yes, live telecast, live telecast.
Do you believe that's the way?
Yes, that is the way. That is the way.
In fact, the Supreme Court, the company headed by Justice Chandrachud, is working towards this
Working toward that,
policy.
and then that is a very positive step, and I welcome it. I welcome it.
Sir, India's legislative scenario has undergone mammoth change since you last held office. Whether it be the abrogation of Article 370, whether it be the Tribunal Reforms Act. As a very senior member of the bar and someone who has adorned the court halls of the Supreme Court, do you think the landscape looks better now, the legislative scenario of the country?
Definitely, because there are varied subjects which were not there, particularly this commercial litigation which we are inviting, our trade agreements, etc. Then environmental law and many other laws which were not there, they are now coming up. Now this real estate law. So all this, I think an interaction between judiciary and legislation sometimes should be there. Only on the bench we say something, and then the legislature takes some steps. Instead of that, there can be an interaction between legislators and judiciary outside the court.
If you can elaborate on this a little more for our listeners.
For example, suppose a particular law is struck down, and now government is thinking for going on for a new law. So instead of again testing it in the court when it is questioned, it is better that the legislators and judiciary sit together and discuss the subject just like a
You are
symposium.
actually suggesting a consultative process.
Consultative process in the lawmaking, in the lawmaking,
Okay.
in the lawmaking.
Because don't you think that somewhere down the line would breach that Lakshman Rekha of doctrine of separation of powers?
No, ultimately, when it comes to court and court proceedings, the things are different. Here, only it is only consultative process. Not that in that consultative process you have to give decisions.
Okay.
It is just a consultative process, as you do in conferences. And there, sometimes judges speak out.
Okay. So, when we compare it to the early 2000s, there is a dramatic change in kind of subjects the courts are encountering these days. Increasing subjects of personal law issues, increasing subjects of faith and worship, increasing subjects of what should people wear, what should people not wear, etc. etc. Has this been the scenario forever, or this is a recent change?
This is a recent, this is because of the human rights concept, human right concept, international recognized human rights.
Okay.
The constitution adopted certain liberties as a part of international human rights because of the Universal Declaration of Human Rights. Other declarations or other agreements at the international level where this country is a member, those are not adopted as such in law. But case by case, Supreme Court is introducing those human rights laws in the by judgments, although they are not there in the Constitution. So actually, Article 21 is being expanded, and therefore several issues which could not have come to court are coming today. For example, where right of entry of female in Sabrimala temple, or this hijab and other things. So these are all coming as a part of human rights concept, human right law, and which is not engrafted in the Constitution, but it is read into the Constitution by interpretation under Article 21, part of liberty. Part of liberty.
But just taking one token point from your answer on hijab,
Hmm.
how do you define someone's right to wear something vis-a-vis with respect to someone's uniform? In the court of law.
That is a tricky question, and that is court has to decide. If there is a uniform prescribed, even all communities, all castes should follow it. Outside the institution, they are free to do whatever they want, but inside the institution, that much restriction they have to follow. That is the course issue which is before the court.
Yes.
So I think on this issue, and even hijab part, if all modern Muslim women are not using hijab, even very educated women in Gulf countries and in Pakistan have left this hijab. So that is only confined to, this is only raking up an issue which is not an issue at all.
Okay. But are courts the correct platform to deliberate on this issue?
As I told you, this is part of that personal liberty.
Okay.
What I should wear, what I should eat, nobody should restrict that right. That is a part of. Therefore, whether it is a reasonable restriction, that would be the question before the court. Whether the restriction that in the inside the educational premises you have to wear, you cannot wear, you have to be along with other girls in same dress. So this is this is a part of personal liberty only.
So there has been a lot of debate, and which also I think you primarily highlighted while we began the interview, as to the retirement age of the judges, and the Attorney General has been very vocal about it. He has time and again spoken about how he's so sad at every retirement that the judges go even before he realize that he delivered certain judgments. So, according to you, I ask a very pointed question: what is the concrete way ahead in this scenario?
The concrete way is to increase the retirement age.
Okay.
And maybe either retirement age is increased, or at least there should be a provision in the constitution that a person who goes to the Supreme Court or High Court must have minimum this much of period,
Okay.
irrespective of his age or her age. For example, if the person reaches Supreme Court at the age of 60, 62, then he must have at least 10 years there. 10 years, 5 years, 6 years, whatever period you fix. A fixed tenure in the Supreme Court and High Court would be the most ideal thing according to me. And particularly from the lower judiciary people come, they just touch and go. At the verge of their retirement, they get chance to become judges, and before they have learned the art of deciding in the High Court, they retire. See the mockery. So why can't we have, as I told you earlier, either you increase the age of retirement in the High Court and Supreme Court, or give a fixed tenure to a High Court judge and a Supreme Court judge. He should be able to perform, deliver. Merely giving a post and giving a salary is not enough. Most of the people now, they have increased the quota in the High Court to 25%, I think, 25. In 25%, so many district judges become High Court judges. And before they have learnt other branches in which they have never worked, there is a time to retire. I am aware when I was practicing, people like Justice Pandey and Justice Rana and many people who are district judges remained on the bench for 7 to 8 years, 10 years, and then they decided tax cases, they decided constitution cases because they could learn. And presently the scenario is a person sometime gets appointment for 2 years, 3 years, even minimum, even 1 year, just to give him a chance. What he will do? Nothing except utilizing the perks and LTCs.
So the period of tenure of the judges has almost become just to utilize the perks.
Yeah. Sometimes it happens.
Okay. So, how do you envision, how do you see the situation of minority rights in India at the moment? Is it in consonance with what the framers of the constitution has had envisioned?
No, minority majority conflict has been there throughout, not only in this period. I think this is an area in which you should not take me because it is more a political question rather than a legal question. So, this conflict with majority minorities already, our constitution makers have thought secularism only with this purpose that even if the majority have a religion of their own, minorities' religion should be protected and they should be allowed to carry on in the manner they like, insofar as the religious culture is concerned. So, that much guarantee if we go to a minority, then this conflict will not be there at all. That balance has to be maintained. Neither there should be appeasement, neither there should be a harassment. Everybody should be free to, and Hindu religion is so diverse, and even amongst Hindu religion there are several sects, several people, several ways. There are even certain Hindus who do not believe in idol worship,
Yes.
like Arya Samaj and others. Only thought, only meditation, nothing more than that, just like Baha'i. So, if it is so diverse, then I think to allow person of any kind, either Muslim or Parsi or Christian or anybody to carry on his religion, that is the most ideal situation. Why these conflicts are being created is it only by people, a handful of people, they have to be restrained. And better atmosphere has to be created like Vivekananda and Vinoba. Vinoba was the greatest saint of this century who not only read all the religions but practiced them and told people the essence of all the religions. He was a very great man and I have not seen a person of his stature who has read all the scriptures of all religions of India. and not will read, digested them and produce books, his speeches, writings. So religion नहीं सीखा था आपस में बैर रखना.
Sir, you were interested, the duty to resolve that allocation of power utilities
हाँ
guideline.
हाँ हाँ.
It was not really a post-retirement job kind of a thing because it was a very prestigious committee which the Supreme Court had asked you to work on. But I wanted to specifically ask you about post-retirement jobs for judges. Do you think it is something that should be open for the judges to accept, or they should disappear away from the public eye?
No, actually, what is happening, as I told you, if the judges are given a longer tenure, they can perform whatever they have been doing. But because that is not the situation, therefore, if you ask a person to retire, doesn't mean he has to just remain and take pension, doing nothing. Then our place is only mental asylum. If our brain has to work, we must have some work to do. And after retirement, person is not good for nothing. He has contributed, as you have come to me and asking me questions on the whole working of the judiciary and that thing. So most of the judges are doing something. If they get opportunity to do commercial law, they do the commercial law. If they have got the commission, they do the commission. And somebody will have to head them. If judges are excluded from this, then this IS lobby will take over. And you know they are working. They carry on the situation with their own experiences and
But
their own.
I would like to interject at one point here. There is this glaring public assumption that a post-retirement work or opportunity often leads to a bias in a judge who is in anticipation of such a post after the
That is, this should not happen. This is just to judge an individual. Normally, a person should not have any bias or any liking or anything of that kind when he is sitting on the bench. But post-retirement, of course, is a very big problem. Our jurist G.P. Singh was a very fine writer of our Madhya Pradesh on interpretation. He has been also of the firm opinion that if you increase the age of judges and retire them on the salary which they were drawing, then don't give them any allurement. There should be no allurement. But the other problem would be there, how to man so many tribunals and from where to get the brains. Because on every tribunal there is a judicial member and a non-judicial or administrative member. From where do you get the judicial member? Then there would be a intellectual crunch, you can say, because very complicated matters are coming before these tribunals, and there should be somebody of that level to deal with them. If you completely bar the judges from post-retirement assignments, from where do you get the people?
So with the advent of technology, courtrooms are becoming more and more digital, as we already discussed. Even though everything is becoming digital, what are the most essential things according to you which must be left untouched in this entire process?
My opinion is that the hybrid system should continue, where it is necessary to go on the IT sector. For example, you are just bothering unnecessarily a policeman or a constable or an investigation officer, or in some remote village some witness is there, you want to take his evidence. The courts can reach to him through this IT. But in any case, there should in this entire court working, human touch should not be lost. If human touch is lost, you are losing everything. Witness must come inside the court for cross-examination, because effective cross-examination cannot take place when a person is on the camera. He has to be in the court if you want to bring out the truth from him. And wherever there is inconvenient for any party, any person to come to court of law, you can use IT. But otherwise, our traditional system should go on. That is my view. This meeting, you are sitting here, I am sitting here, that way. It is not merely dispensation of justice. The justice should reach the person and he should realize that I have received justice. This feeling can come only if there is a rapport between the judge and the party. And even lawyers will not feel satisfied. Most of the lawyers have said to me that all right, this corona period we have tried, but ultimately physical hearing, there is no substitute for physical hearing. Most of the lawyers are telling me, those who are coming to me for arbitration. Physical hearing should be the norm, normal course, and this online hearing should be an exception in a situation like a person is sick, a person is in a faraway places. A lawyer is also not in a position to come like that.
So much has changed since you demitted office. In fact, the very basis of collegium system was put under doubt, then upheld. NJC was struck down, right to privacy was upheld as a fundamental right. The case, Muttoswamy case. If you look back, as you said that your tenure was very limited and very short, just on a hindsight, which are those couple of cases where you feel you could have contributed a lot if you were a part of the bench? I'm sure you would have read judgments of the Supreme Court and felt that this part could have been mine.
Right to privacy judgment is really written very nicely, very nice, and I do not know there could be a better judgment in the case. Very good judgment. And there were many issues which never arose before us, because as you say, the jurisdiction of the court is expanding, ever expanding, because of this human right concept. So that way, I think Supreme Court is performing very well.
But are there any benches where you would have loved to see yourself?
For example, in these right to privacy matter, or for example, this Sabarimala matter, or Sabrimala matter. In the Haridwar case, in which the local municipality has said that in the Haridwar area, there should be no sale of meat and eggs, etc., to maintain the sanctity. The question was, in a secular country, how can you put this kind of a restriction? We upheld it on the ground that Haridwar means the door to God, and there is a sanctity and purity involved. In Vatican City also, there are certain norms. That norms are being followed by every Christian. Similarly, in a place like Haridwar, which is entire Ganges area is for the puja, and people are worshipping there, and arti is going on. So this kind of a restriction can be there. It is a reasonable restriction. So similarly, many issues of religious issues are coming. I would have liked to be on the bench. I would have liked.
Pertaining to the religious issues.
Religious issue also.
So then I have a very.
And then secondly, as on the bench, I had also written this. That some amount of religious teaching is not bad in a secular country, because we are taking moral education only from our religious books. Even if you see your constitution or preamble, it is basically based on Gita. Gita is not used in it, but all people who frame that preamble were very much Gita followers. Majority of the Rajgopalacharya and others. Many people were there. Tilak, Gandhi were very, very religious people, and therefore very broad-minded and very secular. Indirectly, that influence is to be found. I wrote in my article also.
Okay. So there is often, since especially you spoke about the religious issue, this question becomes very important. There is a lot of debate around Places of Worship Act 1991. What significance that holds, etc., is left to the courts to decide. But just as a senior member of the bar and a legal professional, do you think it's time to take a relook at the 1991 Act?
Actually, to tell you frankly, I have not very minutely gone through that act. Okay. But as I find that these issues should have been avoided that are happening. It is only created by people, and these are things which should be halted. Their own RSS chief last said that we should not go on searching in every mosque and every religious place of Muslim, any deity or anything like that. But that is unending. This country has been
Now they also
totally
want to
rooted,
bring the stairs of
and
Abraham.
they should halt. They should halt. Position as has remained on when we regain freedom. That should not be disturbed. Ram Janmabhoomi issue has been decided, that is over now. But end of it, nothing beyond this. And wherever all religions, if you say that God is one, then what is the difficulty? Anybody can pray. I read Chetan Bhagat's article in Times of India. He said that in many countries, in one place of worship, many people of many faiths are sitting there, just like Baha'i temple. You just go inside and sit silent and pray your God.
But isn't India a little different, just another guy? Because India is a very passionate country. We are a very
In a very passionate country, and as a matter of fact, our religious people are very violent.
yes. When we get so
And,
emotional with
but
aspects of-
violence and religion cannot go together. If a really religious person can never be a violent. Violence shows that this country is not religious. This country really is not religious. It has so many superstitions and so much of bad blood in the people. This is not a religious country. There are a lot of spiritual movement is required, like Vinodhan Vivekananda. I do not know when that avatar will take place.
Um,
Here, everywhere the law is being utilized for what purpose? To create conflict and more conflict. Our judges are doing their job, but what our religious leaders are doing? Nothing. And unfortunately, in this country, there are no religious leaders of that stature.
yes,
These are not issues for the court. If you are going into the field of public law or public interest litigation, you must sit with public while judging. There you should introduce jury system. Selected people from the society should be asked to join you on the bench as juries. You take consultation from them. They know many things which you are not aware of. And then you take a decision. They will guide you. If traditions are going on since long and there is nothing wrong with that tradition, why should there be a conflict? And in majority of trials, people know who is the accused and who has done wrong.
yeah.
Judge does not know, and lawyers concede. So unless there is a public feedback, real justice cannot be dispensed. Then it will be only a judgment, that's all, nothing more than that.
So there is a lot of debate, and this is unfortunately my last question. There is a lot of debate around how nepotism has crept deep into the Indian judicial system.
I come from a lawyer's family. I had a background, you can't say that. My grandfather was a district judge in British period before independence. And my father was advocate, practiced for a long period in district court and then in the high court at Nagpur. My cousin was a leading lawyer here and advocate general with whom I practiced here in Jabalpur. So you can't say I have a lot of legal background. And as you say, actor's son is actor, singer's son is singer. So judge's son can be a judge, but of course he should be taken on merit only. Being a son of a judge is not a disqualification. Otherwise, the other extreme would be exclude judge's sons. But if the judge's son is qualified in every respect, then he should be considered like any other candidate. And lawyers and bar knows it. Is a person is taken only because he is a son, or he is taken only because he performs. They are aware, because they are every day opposing them, observing their.
But is it a little easy for a person who comes from a legal family to make inroads into the profession compared to someone who is an
No, it is very difficult nowadays, and majority of even bright students of law, they are being win away by our corporate bodies. And most of our legal brain is working with the solicitors and foreign firms. They are not coming to court because of the package. And secondly, these bright students also feel that if we join the bar, we will take a long period to earn at a level in which we are now working in the solicitor firm. So, this I have tried to answer some of these questions in this book also. Compulsory, every senior must have that a period of internship for a new entrant, and he should be assigned work. Then this, actually we set up these law institutes for the purpose of giving us good lawyers and good judges, but instead that as soon as a person gets a top position, he is offered a position in the corporate office, and thereby they are lured. But if bar with open arms welcome them, then situation will totally change. Then, as you say, son of a lawyer, son of a judge only becomes a judge, that will stop. Right. What is happening when there is already office going on in, then it is easy for example, my son to join the office. Right. But if there is no office, then he says I have to start from the scratch. And majority of the students have passed out after taking loan from the bank, which has to be paid. My parents say, you start earning, otherwise how will you pay the loan? So, I was regularly visiting National Law Institute Bhopal when I was a chairperson there. I was a frequent visitor. Even I have selected the vice chancellor there. So, there I find that they will arrange some kind of a moot court, and in moot court they will select the bright boys and ask them to please call their parents, and as soon as the father comes, they will say this is the package. So attractive as that. And institutes are also allowing them because they fund the entire show. If they don't have money enough, so they allow these moot courts or these competitions, and even they take students to foreign countries like Europe and United Nations. So this is I say that as our bright people, engineers, doctors, etc., are working in foreign countries, so also our lawyers, bright lawyers, are not coming to the courts for practice. This trend should stop. Once our team in the bar decides that we will groom at least 1 or 2 people in our office compulsorily, and I have suggested that every new entrant, every a person who has passed out must have a rural practice for minimum 1 year. So he knows the people, he knows the people, he knows what is happening in trial court, how witnesses are being won over, how police functions, how Patwari Patel functions, what are the issues and problems of the people there. So as in medical education, there is a rural practice compulsory. Similarly, in law, there should be compulsory rural practice for 1 year in official courts. The difficulty is that sit in the Supreme Court and then examine the papers to say that this was not asked, this was not asked. So you go there and find out what are the problems. Witnesses don't speak. When I was administrative judge in Gwalior in Bhind area, the lawyers were telling me the witness is trembling in the witness box because somebody is sitting outside with a gun, that whatever we wanted to say, if you have not said it, we will kill you. Then I said to the judge that what were you doing? If you are aware that he is trembling, you record that he is trembling and find out who is the person outside with a gun. That was the dacoity period. How can there be justice delivery? Impossible.
Very deep-rooted reform.
Very deep-rooted reform, right from police station to everything. And even dacoity started there only because police was totally purchased by higher people of higher caste. Even they will not record FIR. So therefore, people took the law in their own hands. started working on the guns. They are not allowed to cultivate.
This is Bhind area.
This Bhind, and now of course that Dekoti period is over, but I was there as a sitting judge during when that period was in there. This is somewhere in 89, 90s, 1991, 92. But thereafter surrender was there, Vinobaji had gone there, Jayaprakash has gone there, not many people, and slowly peace was restored, not through law, not by punishment, nothing like that.
Thank you so much,
Yes,
sir.
sir.
It was a very enlightening discussion.
Subscribe to our YouTube channel and click the bell icon.